Let's rock and roll. Yeah, okay, having said that, where are we moving to? We're moving to the financing contingency. And we are going to get through it quickly, right? No, not so much. Aaron, feel free to pipe in because you are the expert in this area, okay? Because it's financing, so it was actually perfect timing. There are a few things that from a legal side that I want to point out. And just so you guys know, on the committee, we are working to completely revise the financing provision. So when we finally finish it, hopefully next year, the new contract, this is going to be all new, okay? If you have a cash deal and there is no appraisal contingency, if you have a cash deal, there is no appraisal contingency unless you add that addendum. There's an appraisal contingency addendum. So when you have one of these clients, no, I'm paying cash. The response is, well, you know, no lender loans money without actually having an appraisal done. Are you sure you don't want one? So just be aware of that. A cash offer is no contingencies, okay? It's a much more attractive offer. The next one is contingent upon financing, which is what you see most commonly, okay? It is very important that when you're looking through the contract, you actually fill in the blanks. So it kind of is important. Let's say, and here's a situation that I have seen happen a lot. You have a cash buyer. All of a sudden, they decide that they are going to get a loan. But the contract says cash. Guess what? There is no financing contingency in that contract. There is, unless you add an appraisal contingency, that addendum, there is no appraisal contingency on that contract, okay? So be very careful. If you change midway, the contract says something else. And what that means is if they need an additional 3 days for what, you know, the CFPB, don't get it. If you get all the way to the end and it doesn't appraise, that seller is going to be paying cash for the difference, or they're going to lose their deposit and they could be sued. So have the conversations with your client. Pay attention to the interest rate that they put down there. Come on.
Can I just pause 1 second?
Absolutely.
One thing that is extremely important, and some of you may know and some of you may not, but I've seen this mistake, is if you extend a contract, be sure you extend the financing contingency.
Yes.
That's extremely important. If you do not, you will have an extension with no extension of the financing contingency and deal fall apart.
That is very, very important, okay? Again, if you're extending a deadline, you need to make sure that you have thought through what else is going to be affected. So thank you. What's prevailing interest rate today?
Ooh, we're somewhere around 3.75-ish, 7.9. It's creeping.
Okay. So here's the deal. If you're the seller and you get an offer and the offer includes that the buyer must qualify for a loan with a 2% interest rate, don't accept that. Why? Where is he going to get that? I mean, he's not going to get it. So you really just know what the prevailing interest rate is so that you have a gauge of what's actually an interest rate that is within the ballpark and one that's not. Buyers agents, if you're working with buyers and they've already told you that they have issues in their past with their credit, so on and so forth, you know, you can put a lower interest rate, but you know that they're not going to qualify for that 3.75 rate. It's going to be higher. Why do I tell you to fill in the blanks? Because if you don't, the default in there, and make sure that you follow along on this, okay? If left blank, and I'm reading from line 89, if left blank, then prevailing rate based upon buyer's credit worthiness, okay? So what the prevailing rate at 3.75% may be for some people, or your buyer who's had credit problems and maybe had a bankruptcy or whatever, the prevailing rate for that person may be 12.5%. And that's how the contract is interpreted. Fill in the blank, okay? Just, and again, I give you the extremes so that you guys understand the importance of it. The buyer has to use good faith and diligent effort. So if you are a listing agent, you need to dog the buyer's agent and the lender, okay? You're basically, think of yourselves as the lawyer, not that example. Think of yourselves as the private investigator, okay? And you are going to keep copious notes on every phone call that you made. Why? They're supposed to apply for loan approval to make their loan application within 5 days after the contract is signed. Get confirmation that they've done that. They get a specific period of time to have that loan approval. If they don't have it and they terminate the contract and your seller's out the deposit, your seller's not going to be happy. They basically shifted the burden. You, seller's agent, listing agent, have to be the one to stay on top of. I hear all the time, well, they asked for their tax returns 5 times and 3 weeks later, they still don't have them. Is that diligent effort? No. But if you want to be able to prove that they failed to use good faith and diligent effort so that seller can keep the deposit, you need to document your file, okay? As an aside, guys, if the deposit is $1,000, no, it is not worth fighting over it. Please do everything possible to work it out, because that $1,000 is going to be gone and nobody's going to get anything, okay? By the way, and this goes across the board, confirm all communications with your client, with the agent on the other side, with everyone in an email. You can do it very nicely, but you're confirming what they said. Keep those emails. The buyer has to provide loan approval. So we're actually now on page 3. We're moving right along. The buyer has to provide notice of loan approval. So in that time sheet that we talked about, that chronology, the loan approval deadline is very important. And the deadline is the deadline, okay? And I didn't address this in the inspection period, but the 15 days in the inspection period, you need to terminate the contract by day 15. It's not 15 days to do the inspection and then you get to negotiate the things. You have to negotiate changes. It's fish or cut bait, okay? And if you're talking to the other agent and you're right up against day 15 and you don't have an addendum, an amendment to the contract with the changes, send over that cancellation and release already signed by your buyer to cover yourself so your buyer can get the money back. Sorry, I'm going out of order. I was talking about the inspection period. Back to the loan approval. Okay, if the buyer does not provide notice of loan approval, that they've received it or that they haven't, either way, what happens? That loan, that financing contingency is completely gone, okay? It's as the contract now becomes a cash deal. So if the appraisal comes back and it's insufficient to satisfy the lender, too bad, because you now have a cash deal. The other part, if your buyer really, really wants that property, there's a 3-day window. So buyer doesn't provide notice of loan approval by the deadline. The seller has 3 days after the deadline for loan approval to terminate the contract, okay? So on day 2, you get cancellation and release of contract. Now the buyer gets their deposit back, but seller can terminate. And we were seeing a lot of that when you were having multiple offers on deals. You were seeing a lot of that because they were looking for every gotcha. So best practice, just make it a habit. The day that there's a loan approval deadline, or the day before really, if you still don't have loan approval, you have to be talking to everybody. Yes.
Now, just to be really clear, is that conditional approval or is that like third approval?
Okay. Every loan approval that you're gonna have will have conditions. You will always have a loan approval that will have an appraisal condition to it, okay? It's a conditional approval, but that is loan approval. Under this contract, that is loan approval. What I will always tell people, sit down with your client and go through what is on there. If you know that you over the price, you gave them asking price, and you know that that property is not worth $500,000. Last house that sold a month ago on that street, 3 doors down, sold for 400. Same floor plan. It's not, no house there has sold for 500. You know that that's not gonna appraise, okay? Manage your client's expectations, because they won't get the financing based on the appraisal. They'll get it up to the appraisal amount for the most part. Please correct me if I'm wrong, because I'm not the expert on the loans. So that buyer of yours has to come to closing with the money. And if you don't want, you feel that that's not, you're not really invested in that, the first place they go, guys, to start collecting the money they need to pay is your commission. That is always the first place they go, okay? Stay on top of that deadline, just terminate the contract. They will agree to an extension if they really want the deal to work, okay? Be careful with that. I did add this recently, and it's based on a true story. If the buyer doesn't give written notice that the appraisal, they did not appraise out within 3 days, buyer's gonna lose their deposit, okay? We had that situation. It doesn't come up often. Best practice, as soon as you get that appraisal, if it does not appraise out, you need to inform the seller immediately that the appraisal was insufficient and they are not going to get financing, and they need to terminate the contract and get their deposit back. So that cancellation and termination and release needs to go over immediately. Don't wait around because you're talking to the other agent, because that's what happened in this case. They missed that 3-day window. Somehow or other, the buyer ended up coming up with the cash to get to closing. Okay, I think we talked about this. Please be aware, you know, your clients rely on you. You are the experts, right? We hear all the time now because they can get everything they need online. Everything online, Zillow and all these other companies. Guys, you provide a critical service for your clients, and make sure that they realize that along the way just by doing what you do. If they're putting down 30% and you're thinking that the purchase price is on the high side, guess what? That appraisal contingency under the financing provision, it's not going to make a difference. And the reason is the lender's only going to care about their money. So they've got 70% in there, but guess what? I know I didn't touch anything. It's 70%, so maybe it came in at 65%. Lender's good, he doesn't care, but your client, all of a sudden, even though you told them they were overpaying, now that's an issue. Your client is not protected. Your best practice always is to include the addendum for the appraisal contingency. I had a situation one time where a very experienced realtor called me up because they were dealing with a client who was making an offer. The wife had to have the house. They needed to have it. There were other offers. They wanted their offer to be very attractive, and they refused to add the appraisal contingency to the contract. Okay? I did explain everything to them, to this particular agent. I then got on the phone with the clients and explained everything, that they really needed that appraisal contingency. Listen, they have it. Doesn't mean that automatically they're not going to buy the house. Maybe the wife insists that they're going to have that house because she has to have it. And even though it didn't appraise out, they don't care. They've got the cash. They're going to close. But that needs to be there. Otherwise, they're not protected. In that situation, they finally came to their senses and tacked on that appraisal contingency. And oh, by the way, the house didn't appraise out, and they were thankful because they had a way out. So make sure that you do that. All right, we're gonna go on to paragraph 9. Seller, we're talking about closing costs here, okay? So these are the typical, what I have up there is the list of typical costs that the seller pays. The seller's going to pay for your documentary stamp taxes on the deed, and that's based on the sale price. The owner's policy and charges, and that includes the title search, by the way. We're going to talk about that in a moment. If the seller pays, the seller picks. If the buyer pays, the buyer picks. In this part of the state, the seller picks the title insurance company. In the South, and in other places up north, the buyer picks the title company, okay? So if you have a buyer and they insist on using someone, maybe it's their brother or sister, they can do that, but they have to pay. The seller should agree to that because the seller is out less money. Okay, just for funsies, if you look in paragraph 9, well, I like to point this out because these are the issues with the contract. If you look under the cost to be paid by seller, and you look on line 130, I think that is, see where it says title search charges? Yes, title search charges. It says if paragraph 9C3 is checked, when you go to paragraph 9C3, it doesn't apply to anyone here. It applies to Miami-Dade County, right? So one would think, well, then seller doesn't have to pay for the title search. That's a separate fee. You pay for the title search and then you pay for the settlement fees. Oh, but if you go over to the standards, okay, they define what is included in title. I think it's back here. And they define it back in the standards as including the title search. So the seller, if the seller is the one picking the title insurance company, the seller pays, and the seller pays for the title search.
What line?
In the back, I can't get my hands on it real quick. Hang on. Hang on. It's under the standards. I think it's up here. Because they actually define what is included in the title. They define title search is what it is. And they define it as including. Yeah, that sounds about right. No, it's not up there. It's title evidence restrictions.
Is it under standard A, Mr.?
Yeah, that's what I'm looking. I'm pretty sure that that's where it was. I apologize that I didn't have it marked. There is it's a definitional term, and that's why it's included in there. That's where they define. I promise I will find it and I will email everybody the exact line so that you're aware. That's one. I haven't seen the issue come up, but to buyer, to closing day, buyer may extend. Hang on. It should be in there. I will email everybody with the exact line number. I apologize for that, but it is included. What prompted me to look that up, just so you know, is recently I was reviewing the contract again and getting ready for a class, and I noticed that it was specifically included under the buyer's costs. It specified it. If 9C2 was checked, where buyer picks, buyer pays, it includes. So when you look on page 3, paragraph 9, and it's under B, costs paid by buyer, owner's policy and charges if paragraph 9C2 is checked, okay? And charges includes the title search, all right? So there was a discrepancy, and that happens all the time in the contract, okay? You just need to be aware of it if that becomes an issue at closing because the seller does not want to pay the title search fee. It's included. That is a seller cost if seller's paying for the policy. The municipal lien search, this is another one. Guys, under the contract, it is required. A municipal lien search must be done. Either the seller pays or the buyer pays. It all depends on which box is checked. I am here to tell you it is not being automatically done by all title companies. So best practice, send an email with the contract and in caps and bold, make sure that you let them know that buyer requests a municipal lien search and a permit search, because it is not an automatic with a lot of companies. They don't do it. And here's the reason why. They didn't realize that the contract changed back in 2013. So it's been a while, but it changed and now it's required. And a lot of them didn't know that. So they only order those when asked. So just avoid it, just ask, all in bold. The HOA condo association, the estoppel fees, that's a seller cost. And the recording fees, if there's anything wrong with title, whatever needs to be done to cure title. Recently had a situation where they needed a quitclaim deed. Paying the recording fees for that quitclaim deed fell on the buyer, on the seller. Okay, buyer. There's taxes and recording fees to record the notes and mortgage, right? Seller's not going to pay for that. That's a benefit to the buyer. So the buyer pays for that. The buyer pays for recording the deed and financing statements, anything that goes beyond just the owner's policy or the warranty deed transferring title. Okay, guys, now we get to a part, and I'm going to stress this, the survey. Oh, I hear chuckles because some of you have been to my survey class. It takes a class all by itself. Here's what I'm going to tell you. Look, some folks have a high tolerance for paying for surveys. There are folks that'll accept a survey that's 20 years old. Doesn't even have to be certified to the seller because the seller moved 5 people ago, okay? A survey that was 5 years ago. You think you are doing your buyers a favor by saving them money, right? They cost anywhere from $300 to $450. You are not doing them any favors, and they will blame you for this. The lender requires a survey, okay? And the lender doesn't accept a survey that is certified to somebody else. Maybe if it's done within a short period of time, they'll accept it as long as they recertify it to the lender. But they don't. You need to explain that to your client and just let them know, listen, the lenders all require a survey. And I recently came across one lender that didn't require it. I was kind of surprised. I know, but they didn't. It could be a seller who bought the house within the last 4 years and they have a survey that's 4 years old. That seller can provide their affidavit. It was certified to them. That seller can serve the survey. They can sign an affidavit because they will have to sign an affidavit at closing that they did not do anything to the property affecting the boundaries and nothing that was, they didn't add anything that's not already shown on that survey. Awesome. Who knows what the neighbors did? Okay? And it happens all the time. So when your buyer goes to add the pool and suddenly they realize that their neighbor's fence is 3 or 4 feet in their property line, who are they going to be mad at? You. You didn't tell them that they really needed a survey. You're saving them $400, but it's going to cost them a lot more than that to get out of that. And if you discover it before closing, that is a defect that the seller has to fix. Okay? So you are not ever doing anybody any favors by getting the survey from the prior owner. It's addressed in the contract. I know it is. I know Fidelity will accept a survey that's 20 years old. I about fell out of my chair. They're the largest underwriter in the country, so they have big bucks. I don't like it. So, and just so that you guys are aware, there is a Florida statute that requires, so when you get your title commitment, there's always an exception for matters that would have been shown by a survey. Under the statute, if a survey is done within 90 days of the closing date, and it is certified to the buyer and the lender, then that exception falls off automatically by law. It can't have it. So that's where all of this started with the old surveys. Oh, give us the old survey. You're not helping them. On there is the list of what the buyer pays. If the owner is paying for the owner's policy, the borrower has to pay for the lender's policy. The lender's going to require a title insurance policy. Advise your clients if they have to pay for the policy, you'll see in the contract, they have to pay for the municipal lien search as well. The appraisal fees come in. This is going to change in the contract coming up. Next version of the contract, we're having a lot of deals. We're seeing a lot of deals that are falling apart within the last 3 or 4 days right before closing because of the appraisal. The appraisal contingency is going to be part of that 20-day period or maybe 5 days out. We're still working on that, but they can do it and the lenders can have somebody out fairly quickly. The problem is the buyers don't want to spend the money. So, okay, we talked about the survey. Disclosures. I'm going to actually fly through this because I'm going to teach you guys. I have an entire class on disclosures. Radon gas, it's naturally occurring. It has to be on there. Please note line 195, okay, on page 4. The reason I want you to look at that is because that section addresses permits disclosures. This is a huge difference between the as-is contract and the regular FAR/BAR contract. Under the as-is contract, the seller only has they have an obligation to disclose if they know that there are open permits out there. The only thing they have to do if there are open permits out there is provide the buyer with any documents, plans, drawings, anything that they have relating to that permit. The seller does not have to pay for anything. How do you protect your buyer? Get that permit search very fast while you can still get out of the contract, okay? And permit searches have nothing to do with title, which is why title companies don't automatically order them. So you have to ask for them to be ordered. My suggestion is, again, in that initial email, ask for that permit search immediately so that within the inspection period, you can terminate the contract if they're outstanding permits, because under this contract, it all falls on the buyer. And if you have to do something and that permit is going to be closed now, you have to comply with the code provisions in existence today, and that can be costly. I have a permits class 2, so I'm not going to go into it, but they are sunsetting them, yes.
When do the permits need to be closed? Prior to closing, at what point?
They're supposed to be closed within the time frame that, I think they're open for 6 months, and then they're supposed to be closed. Basically, when the work is completed, the inspector comes out, approves it, the permits are supposed to be closed at that point.
As long as it's closed before you-
Right, you can close the deal and the permit can be open. It doesn't, yeah, we don't get involved in that. Okay. The flood zone. There's been a lot of discussion on this, guys. Okay, if you know you live in a neighborhood, or not you, but your sellers live in a neighborhood and it was all over the news. In fact, it was their house that had 5 feet of water running through it. It has to be disclosed, okay? And anyways, disclose it. That means that the buyer can't come after you for failure to disclose. I don't believe I see a lot. I think all of you are real good at attaching that energy brochure. It has to be attached, so make sure you attach it. And the buyer has to sign off that they received it. Lead-based paint disclosure, everybody's aware of that. When you're looking at older homes, if it's before 75 or earlier, you have to include that lead-based paint disclosure just to inform them. FERPTA. All right. I used to not say anything about this. I used to tell everybody, just send your client directly to a tax attorney or an accountant. However, if you're the listing agent, you need to manage your seller's expectations. So if your seller is a foreigner, please make sure that you ask them. If you're not sure, ask them. There are very polite, nice ways to ask them. Because you need to let them know you should contact a tax attorney or an accountant. I can't give you legal advice. However, if your home is purchased by someone who will not be living in the home, it's an investment, they're going to have renters in there. The buyer will be responsible for withholding a certain percentage, 15%, and it's on a sliding scale, of your proceeds at closing and give them to the IRS. The faster you go talk to a tax attorney or an accountant, you may be able to get all your documentation, all your ducks in a row so that that amount isn't withheld. I'm painting with a broad brush, just so you know. There's a threshold above which that will be withheld. So anything that falls below it, but that is what I want all of you to take from here. You really need to manage your seller's expectations. I did have a client with a multi-million-dollar deal. Seller did not know because seller had not been educated about that part of FERPTA, okay? The disclosures. And I saw this. Oh man, is Damien here today? Okay. We had a lovely conversation exchange last night, several realtors and myself, and it dealt with disclosure. It was actually an interesting topic. Here's the deal, guys. All right, what's Florida law with respect to disclosures? Florida law under Johnson versus Davis, and there's a whole section in your materials, I'm not going to bore you with it, but the Supreme Court of Florida has ruled that if an owner, a seller of a property is aware of a defect that's not readily observable, maybe a big hole in the house that you can't see because it's covered. If you walk in and you see the big hole, that's not, it's readily observable. But something that's a hidden defect that isn't readily observable, the seller must, there's no exceptions to it, seller must disclose. People try to skirt the issue because they don't have to provide disclosures in writing, okay? I have fought with the folks at Florida Realtors and on the committee to add the requirement into the contract that sellers' disclosures written seller's disclosures be mandatory, and they're not. There's a lot of attorneys currently out there, and this is a change. A lot of attorneys are out there currently advising their clients not to provide written seller's disclosures. Remember at the beginning of the class, I said that my practice is different because I want to protect you guys. They don't have my practice. You are protected when your seller provides disclosures. Your sellers are protected when they provide written disclosures. As I understand it, the attorneys are telling people, their sellers, oh, no, because what if you say no and that's a misrepresentation? Well, guess what? Failing to disclose something is a misrepresentation and they're gonna get tagged. However, this is where you come in, where it's important for you guys. Guess what that seller's gonna say when they're faced with that lawsuit? Oh, but I told Kim, I specifically told her blah, blah, blah. And Kim knows that they didn't. However, Kim has nothing in writing to prove that he didn't. But if seller provided written seller's disclosures, and they're brokers, by the way, who are telling their agents not to get them. Yes, several, it seems to be multiplying. It is the worst advice anyone can ever give. I have litigated a lot of failure to disclose cases. This is the #1 type of case that I deal with, and it is easily avoidable. Disclose, disclose, disclose. One of the realtors in on that exchange last night, I loved it. It was disclose, 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 which is a title of a class I teach, okay? Anything that materially affects the value of the property must be disclosed. As hard as you can, you need to explain to your seller how you're protecting them, because if they have a leak in the roof and they think they're not going to get all the money that they're asking for the home because of a leaky roof. Listen, okay, people don't usually have roofers come in and inspect the roof. When that roof starts leaking at the first rainstorm a week after closing, they're going to call a roofer. They look the roofer up on Google, or one of those neighborhood things where they ask for a recommendation. The roofer's going to come out. I was just here 3 weeks ago. I actually had a case where the plumber that came out was the plumber who had come out 2 weeks earlier and still had the estimate that they had given the lady. Share that with your clients. We live in a world that's this big, okay? That plumber, roofer, yeah, they're the key witness that that seller was aware of the leaky roof. The seller's disclosures are really nothing more than a roadmap, a guide, so that when the buyer has their inspection, the inspector can go through and maybe they want to hire a roofer because there was a roof leak. So now they're going to get a roofer up there. Just explain that to your sellers, because what happens when there is a failure to disclose, here's who they sue. Both brokers, both agents, and the seller, okay? And litigation is not cheap. Everybody has E&O coverage. However, time is money for you guys. If you guys are not out there, you're not making money. And as much as I love all of you, I don't think you really want to be spending a day with me preparing for a deposition, a day in deposition, and 2 days sitting in trial. How much money does that cost you, even if you win? So educate your clients and get those disclosures. I'm going to skip through. By the way, I do want to mention Jensen versus Bailey. In that case, the Second District Court of Appeals, which is the court that governs our area, the appellate court said that what the seller has to disclose is what the seller is aware of, what they know of, not what they should have known, okay? The standard is known, not should have known. So they limited that. Here I go through what to disclose. You guys will have the list. Termites, sinkholes, drainage problems, flooding issues on docks, plumbing leaks, roof leaks, basically anything that might be an issue. And when they go through those seller's disclosures, it should prompt them to remind them So, and if you guys come, when I have the seller's disclosures class, some of you probably have it who've come to it, but I created a form. The content comes directly from the Florida Realtors seller's disclosure, but it's all laid out where it's in larger print and the box, it's all boxed in. There's 3 boxes, all right? When you get that, oh, but I'm a flipper. I've never lived in the home, so I don't need to do it. I'm exempt. I actually got that one a few weeks ago. Nobody's exempt. Nobody is exempt ever from seller's disclosures. If they're aware of a problem, and the flippers are the ones that are absolutely aware of problems, because flipping that house cost them more money because they had to pay to have things fixed. They know, and that contractor they hired is going to sing like a canary, okay? And you guys can't put blinders on when you're doing that, okay? All right. So if you come to my class, How to Disclose, the Best Way is in Writing. I will give you the form that is easier. I hear all the time, oh, but it's hard to follow. No, my form, it's easy. It's all in boxes, okay? And there's 3 columns in there. Yes, no, I don't know. That's what if the flipper wants to play games, I don't know. We've talked about most of this, okay? Here's what I'm gonna leave you guys with so that we have questions and answers at the end. Guys, don't walk with blinders on, okay? Make sure you're listening. You need to listen. If you're working with buyers, listen to what the buyers are telling you and what they're not telling you. And if you're working with sellers, listen to what they are telling you. Pay attention. When you're sitting there and but I thought they just said this and now they said that. Chances are they really did say this and now they said this, and something is amiss. If your gut is telling you something's up, follow your gut. I'm telling you, my gut has never been wrong. And if you read a lot, all these, productivity books and all of that, they all say the exact same thing. Follow your gut. So if you just get a feeling that something's up, maybe it's a $2 million listing and you're dying to have it. It's not worth it, okay? My advice, always complete the seller's disclosures. If you have clients who refuse to complete them, as long as they're not represented by an attorney, I'm happy to have a brief chat with them and explain the benefits of that to them. If you're, this is the other key. You guys all know that you're responsible just as much as the seller if you are aware of a defect and you failed to disclose it. Okay, so it's not just the seller. As for the buyers, somebody recently asked me, this came up within the last week, always recommend to your buyers that they have a home inspection done. They're not really saving anything. Encourage them to have a home inspection. The call that I received was, well, they really wanted the property. They didn't have a home inspection done. They didn't have a survey done. And there was a problem, of course. And so he has no claim. There's nothing. It was whatever the issue was. It may have been a leaky roof. It would have been easily, rectified had he had the home inspection. Okay. If your client won't, I'll leave you with 2 more things on the disclosures. If your client is Spanish speaking or speaks a foreign language, let them find their own translator. Do not ever, okay? JR over here speaks Spanish. He can't ever translate those disclosures for a seller. Why? Because the seller's gonna say, I told him, or I didn't understand, he didn't explain that, he didn't read it. So they need to find their own translator for those sellers' disclosures. Don't ever put your pen to paper on the disclosures, by the way, and don't ever sign them. Had a broker one time that was their favorite. way of handling disclosures. It was a one-page disclosure, and he had his agent sign them. Real quick, I include this in here just for some of you who maybe dabble on the commercial side. On the commercial side, no disclosures. It's buyer beware, caveat emptor, okay? And the reason for that is when you're dealing in commercial property, it's the buyer's obligation to conduct due diligence, and usually you get on average a 60 to 90 day period the buyer does to conduct all their due diligence. So that's a big difference. Dispute resolution and attorney's fees. People ask me all the time, why do you prefer the FAR bar contract over the CRISP? And I'll be the first to admit the CRISP contract is much easier to understand. It's written in plain English. However, the CRISP contract requires arbitration and does not allow for the recovery of attorney's fees. And in the United States, you're not automatically entitled to attorney's fees in anything. The only way you get to recover attorney's fees if you win at trial is if a statute provides for the recovery of attorney's fees, or if in a contract the parties agreed that the winning party, prevailing party, recovers attorney's fees. And the CRISP does not do that. In my prior life, Dean's here so he can attest, I have probably had over, definitely over 50, probably close to 100 arbitrations in my career. For 10 years, I tried cases in arbitration throughout the country. Arbitrators always split the baby. They're not judges. They're in their human nature. Sometimes, by the way, they don't even have to be lawyers. In their human nature, they want to just split the baby so everybody gets a little something, not do what's right. All of the cases I arbitrated, they always had that inclination. I won one outright, and the client was still, I can't believe this. Why? It cost him 400 grand to win his principal. I told him to settle early on. Cost him 400 grand to litigate that case to get his principal, okay? In arbitration, it used to be that in arbitration, it was quicker. It's not anymore. You are now seeing a lot more attorneys saying arbitration is not there, is not the way to go, and it's very expensive. You have to pay a filing fee that's based on the amount of the complaint, so the value of the property. You have to pay the arbitrator an hourly fee, probably around $250 to $300, maybe more. You have to pay the American Arbitration Association an additional processing fee that I think is a couple of $1,000s. And I mean, you just keep tacking on. When you have litigation in court, our taxes pay for the judge's time. So it gets, you're not paying for the judge. Standards, real quick. So title exam is covered in the standards. Here's what I want to make sure you guys know from that, okay? And you can look at lines 317 to 377. All right, that title commitment needs to be provided to everybody as soon as the title agent has it, okay? Typically, it should be ordered right away. There's a lot of title companies that don't order it right away. They want to wait until the inspection's done. I order it the moment I get the contract. That way I have it. As soon as I get it, I provide it in its form to the parties. Why? Because the buyer has 5 days to review that title commitment and the exceptions that are on there, okay? The buyer has 5 days to review that commitment. You know when they usually get the commitment? About 2 to 3 days before closing. Why is that a problem? Because the buyer has 5 days to review that title commitment. You've got closing in 2 or 3 days. What does that mean? You're not closing in 2 or 3 days. So make sure that that commitment is provided to the buyer as soon as they have it. Doesn't mean that that's the final commitment. It's not. It just identifies what the title agent has to do or provides the instructions for what has to happen so that the title insurance policy can be issued. We talked about the survey. The liens, we talked about that. At closing, by the way, everybody has the form that the seller is not aware of any liens that have been imposed or that are gonna be imposed. They're not aware of anything like that. Don't see a lot of litigation on that. Time, it's calendar days, okay? And I told you at the very beginning that most of the important information is buried in the standards. Back here, standard F is the one that tells you the question relating to what Dara asked. So the time for acceptance and the effective date, so those two time periods, all time periods end on the weekend or on the next business day at 5 o'clock, okay? All other deadlines are through midnight, okay? So what that means is if you had the home inspection deadline and it fell on Saturday, let's say, yeah, it fell on Saturday, the buyer has until Monday at 5 o'clock to terminate the contract based on the home inspection, okay? Not till midnight. Then if the buyer had through Monday, if the Monday was the deadline, buyer has until midnight. It's only when it's an extension that they get till 5 o'clock. We just like confusing everybody. And maybe the easiest thing is to think of it in terms of, you know what, every deadline's at 5 o'clock. I need it before 5, get it out. That way you never miss a deadline. Okay. And Dara, I'm gonna go back to the question that you asked. And there may be, I'm gonna look at it because there may be an argument that because it's the effective date and acceptance, that those dates are firm. So under the example that you gave me, it would be, the deadline would be Sunday, not till the next day. We talked about force majeure integration. What that means, guys, is that the only thing that matters is what's written in the contract. There are no representations that are verbal. You can't believe anybody. It doesn't exist if it's not in the contract. By the same token, after you sign the contract, no conversations, no one's bound by anything because you cannot change the contract unless it's in writing, signed by both parties. I think, yeah, we got to the end. So give me 1 second. Dean, can you go get the salesperson, please? Ask them where Randy is, or call Randy and ask him, sorry.
Do you want to do questions?
Yeah. All right, now we have, gosh, we have almost a full 20 minutes for questions. Questions?
I think line 150 addressed your title search questions.
Ooh, let's get back to that. Yay. I knew it was in here. Ah, thank you. It is, you know, and I have it highlighted, but I skipped right over it. So guys, when I said that the seller pays for the title search, but the title search is not specifically itemized under the who pays for what, if you look at line 150, I am going to read it to you. The owner's title policy premium, title search, and closing services, collectively, they refer to them as owner's policy and charges. So the title search is included as part of the definition of owner's policy and charges. Does everybody see that? Okay. Let's now go to section, excuse me. Okay, thanks. When you look 9A, what's to be paid by seller, okay? Owner's policy and charges. Do you see that? It's item 2 in the list. Normally, you have a definition that precedes the term. Here, the term goes before the definition. So, owner's policy and charges is what's defined in section C as title policy premium, title search, and closing services. Okay? Yes.
If we're,
Thank you, Erica.
if we're asking the seller to pay the buyer's closing costs or a portion of the closing costs, is that something that should be in that section 9? Or is that something that should be in section 20? Or both?
It should be in section 20.
In section 20.
In section 20, and you can just add, seller agrees to contribute X amount towards buyer's closing costs. Be specific, by the way. If the seller is only agreeing to pay for certain costs, list them. Had a situation where the seller was contributing $10,000 towards closing costs, and the buyer had every inspection under the sun, had a septic inspection, had inspections I'd never even heard of, and now the seller didn't want to pay for it. The only thing that they said in section 20 was seller will contribute $10,000 towards closing costs. They're all included. So be careful. Just if the seller intends to be very specific, include the specifics. Anyone else? Yes.
Finance contingency. How long does title company / attorney would have to return a deposit if the buyer fails to take financing?
It really shouldn't take long at all for whoever's holding escrow, okay? The question or the key is, when does title company or attorney get the fully executed cancellation, termination, and release of funds? Because the escrow agent cannot release any money that they have. The escrow agent can only release those funds according to the agreement of the buyer and the seller. So the buyer and the seller have to agree and direct the escrow agent on what they're supposed to do with the money.
What if the agent refuses to deliver the release and cancellation to the seller?
Okay. In that scenario, what you need to do is you or your broker should reach out to the broker on the other side. I'll preface that with, I'm well aware that oftentimes the ones you have the most problems with are in fact the brokers, and they're usually a broker that has, just the broker, maybe one other person. But that's what they're supposed to, that's what's supposed to happen. In some instances, if they push it far enough, document your emails, report them to FREC. Okay, report them to FREC. I'm gonna tell you guys, FREC can't do anything if they don't know what's happening. So when you see other agents doing things that you know are direct violations, and there's a lot of agents out there that do the exact same thing time after time, everybody knows it, the ones that want to get both sides of the deal. So they don't present offers because that wasn't their buyer's offer, that kind of stuff. Everybody knows what they do, but nobody reports them. Nobody wants to be the snitch. FREC can't do anything about it. So in a situation like that, document, paper, and then eventually ask, an attorney. I hate saying this, but legal letterhead has this effect on people that forces them to act, the way they should act. That agent, it's his client that doesn't get the money or does get the money, whichever end they're on. But if they don't do it, provide a copy of it to the title company or the attorney and let them know, on this day I called, on this day I emailed it to them, I followed up, here's my copy, it's dated before the deadline, the loan approval period, but they refuse to sign. Sometimes, depending on how clear the situation is, sometimes attorneys will release the deposit because they feel comfortable enough that there's no way they have no entitlement. But it's not often, and again, risk, how much risk are they willing to take? Anybody else? No? Yes. Tara? Oh, Erica.
Thank you. Just questioning back here to the escrow agent, line 32. Where it says escrow agent information, do you think it's okay just to go ahead and put the name of the company?
Absolutely,
Without a name?
correct. That's what you should be putting in there. You should be putting the title company name.
Because then it should say escrow agency information.
Yeah, you know, we spent days going through page one, and at the end of days of debating page one, we made one change. We removed the fax line that appears on there. Guys, I cannot make this up. I have the documents to prove it because I keep them all, okay? I spend 4 hours driving over there, two back. I sit through 6-7 hours of all of this, and yes. One time I thought I had missed an entire session because I went back through my notes, and I'm like, but I have all of this verbatim. And so finally I said, I must have missed something because we already agreed on all of this. Why are we revisiting? Oh, yeah, well, we agreed, but this person didn't agree, so now we're going back to revisit it. So we removed the fax line. It would probably take us at least 6 hours to agree to change that to agency. I'll bring it up, though.
I just want to make a comment. I appreciate you coming here, sharing your time and giving us this knowledge. And I would encourage everybody here to let other agents know to come next month and future months.
Thank you, Dara. I appreciate that. Thanks, guys. Thank you for coming. We'll be here first Thursday of every month, and you guys be on